My name's Alec Osland, and I'm an attorney at the Yanowitz Law Firm, where we've been helping families with wills, trust, and probate for over 30 years. Today, we're going to talk about how to set up your estate plan to protect your children from potential liability. The general rule with estate planning and liability protection is that if a trust is set up for someone else's benefit, they may have some liability protection depending on the trust. If you set up a trust for yourself, the general rule is there is no added liability protection. How does this liability protection work for your children? So how it works is that we generally have certain provisions that protect the child's assets that are being held in the trust. What that means is that even though the assets are for the child's benefit, the assets are not actually in the child's name. They're held in the name of the trust, which results in the child not actually having direct control over those assets as an individual. These provisions can protect the trust assets if the child gets sued, goes bankrupt, or even potentially gets divorced, as those situations would all impact the child on an individual level. And since the child does not individually own those assets, the trust does, the trust assets should be protected from all of these liabilities. Now, there are three different ways that we can distribute trust assets to a child following the death of the parents. One way is that we can distribute those assets outright. Another is at trusted ages, or we can have a lifetime trust distribution. With outright distribution, that means that once the parent or both parents die, those trust assets, they pass outright automatically to the child. In that situation, the child would not have any liability protection over those assets that they receive because those assets are being distributed to them outright. So there is no real liability protection with that type of plan. With trusted ages distribution, the trust holds the assets until the child reaches a certain age, and then the trust distributes those assets to the child once they hit the required age as identified in the trust. We generally don't recommend having that age, below 25. We can also set staggered distribution, so maybe the child gets a third of the trust assets at 25, half of the remainder at 30, and then the remaining trust assets at 35. With a plan like that, the trust assets can still be used for the benefit of the child prior to those age distributions, but we have standards that the trustee has to abide by, and they can use those trust assets for the child's health, their education, maintenance, and support. It's just that the child is not getting those assets in their individual name until they hit those certain ages. One of the benefits of holding those funds in the trust, besides the fact of maybe the child isn't mature enough at a younger age to inherit those assets, is that while those assets are being held in the trust, they are going to be protected from any liability that is going to impact the child on an individual level. So if they get, sued at the age of 22, as long as those assets that are being held in the trust and the trust isn't supposed to distribute those assets at the age of 22, the trust assets should be protected from liability from third parties. That being said, the liability protection does end when those trust assets are distributed to the child when they hit that certain age. With lifetime trust, the assets are held in a very similar way as the trusted ages. However, there is no set time or age when those assets have to be distributed out to the child. Essentially, we have this trust that holds those assets for the lifetime of the child, and those assets are used for their health, education, maintenance, and support. With lifetime trusts, we also generally draft provisions that allow the child to be trustee of their trust once they hit a certain age. For additional liability protection, since the child is serving as the trustee of their trust, we generally like to have language that requires a co-trustee to be serving with them, who is going to be someone who is an independent trustee, just for more liability protection. I'd like to thank you for joining me today to learn about how you can protect your children from liability regarding the assets that they're going to inherit. Feel free to subscribe to our YouTube channel to find out when we post another video about estate planning. Thanks, and have a great day. Bye.